We've been receiving a number of questions from our mining clients recently of matters relating to what it's going to look like on reopening either head offices or operational and other offices that have been closed during COVID. We've asked Nancy Romalo of our employment and labor group based here in Toronto to give and share with you some of her thoughts on these matters. What we've done is taken the questions thematically that we've received, put them together. I'm going to put them to Nancy, and we will all share in her wisdom as we all go back to work. So Nancy, the first question, and I'll just read it to you, is, are there employment or privacy issues around testing people every day before they enter the site? For example, if someone tests positive, the fact that they have been sent home that is broadly known, and would this breach confidentiality or other obligations in a circumstance?
So Jay, that is a very common question. As we come to appreciate, screening measures have become a key element in an employer's toolkit in these circumstances as they manage the risk of contracting COVID in the workplace. The types of screening measures being used by our clients range from anything from an app where an employee answers a questionnaire to mobile testing sites on mining sites. And so the any of those screening measures will come with some privacy concerns. So using the example that you gave us, if the employee is testing and they're testing behind a screen and they go home that day, well, it's obvious that everyone's going to know that there is some reason for the individual going home that day, and it's likely because they failed the test. So as an employer, you're balancing this obligation to protect your employees' privacy rights and to ensure that you're taking every reasonable precaution to ensure the safety of a worker. So in order to manage this risk, and more importantly, in order to assure your employees that you're taking their privacy concerns into account as you progress through, you want to think about some of the following. How is the information being taken from the employee? For instance, in your example, is it behind a privacy screen where there is some distance between the employee and the employees who are being tested? How is the information collected being stored, or is it being destroyed automatically? In the example of the app, is that information automatically being deleted? And then how is information being communicated to employees? Using the example of an employee who tests positive for COVID, how is that being communicated? What's the contact tracing look like? And ensuring that that individual is never really identified. Having considered and addressed these factors in policies or in procedures will demonstrate to your employees that you're taking reasonable precautions to ensure their privacy. We have received some comfort recently on this kind of measured approach. For instance, the Ontario Human Rights Commission has just released a statement indicating that temperature testing in the COVID circumstances is reasonable. And we've also seen a willingness on the part of employees to allow for things like temperature testing. In fact, one of our clients who operates a food manufacturing facility recently had a group of employees come and ask for temperature testing to be part of the screening process. All to say that it is a balance of managing these privacy concerns versus the risk of maintaining a safe workplace.
Thank you. The key words that I've heard you say in that relate to reasonableness, measured responses to things, and about process. And you put that together, it's never necessarily going to be bulletproof, but you've certainly mitigated yourself by taking it on and thinking about it that way.
That's exactly it, Jay.
Okay. The other question that we had, for people with underlying health conditions that put them in high risk categories, if they had nonetheless wanted to come back to work, should this be permitted, or does it create liability that should be restricted by an employer? If they don't want to come back to work, on the other hand, or if we restrict them, are they then placed on paid or unpaid leave? How does that work?
So we've seen a number of issues associated with bringing employees back to work. For employers who operate essential businesses, we've already seen a reluctance on the part of employees to come to work. So when you add the added factor of an underlying health condition, this group raises some additional considerations. So let's talk about the employee who doesn't want to come back to work. In many jurisdictions, they'd be eligible for a protected job leave because of their underlying health condition. And in that case, they could either go on the CERB, or we've seen some employers amend their vacation policies to allow them to take some paid time. In terms of Ontario, the job protected leave has no time limit. That is yet to be distinguished based on how long the COVID circumstances will continue to exist and the emergency leave put in place. With the availability of CERB, we've actually seen a lot of employees take this option and stay out of the workplace because of their underlying health conditions. For those employees who want to come back to work with underlying health conditions, that does pose a positive obligation on the employer. Remember, your obligation is to ensure that they can perform their work safely. If there is an underlying health condition that they've disclosed, you want to ask for a medical note that allows them to return to work with or without restrictions. If there are restrictions, this leads you right into your normal course of accommodation, because the underlying disability, the underlying condition can be considered a disability under the Ontario Human Rights Code. So for that perspective, you want to ensure that you follow your accommodation processes. You want to get a doctor's note that lists the restrictions in order for you to assess whether you're either able to accommodate this individual. If you can't accommodate, then that individual is not able to return to work, and they're either going to go on the CERB, or depending on your health, your short-term disability policy and sick leave policy, they may be eligible for short-term disability or paid sick time. So the idea is that you want to ensure, again, this balancing act of ensuring that you bring back employees with underlying health conditions that aren't going to pose a risk in the workplace to themselves.
And the medical note, as in other circumstances, seems pretty fundamental to that.
It does, yeah. So the only way to assess whether you can accommodate is by having medical evidence as to the restrictions that the underlying health condition will impose.
Got it. Okay. And lastly, Nancy, with respect to our mining company clients that would have fly-in, fly-out operations, with potentially contracts and union contracts as well. Can your thoughts? Can these be unilaterally changed for rotations, from say 2 weeks on to 2 weeks off to longer, to mitigate against risk and keep people in essence quarantined at a site? So from 2 weeks, say, to 4 weeks, so it makes it less risky. Have you been? What are your thoughts on that?
Any change to terms and conditions of employment can constitute a constructive dismissal. And so that's the backdrop upon which we make these types of decisions. The reality is many of our employers are making these types of changes, whether it involves reduction in pay, whether it involves reduction in terms and conditions like the ones that you've indicated. The question becomes, how do you address them, and how do you ensure that this risk of a constructive termination claim is mitigated? In Ontario, we've seen the Employment Standards Act being amended to allow for these types of changes to not be considered a constructive dismissal claim. So a reduction in wages or a change to terms and conditions of employment. That addresses the employment standards. It doesn't address the wrongful dismissal claim. So in looking back on employers who have been successful, where we have not received demand letters, and in fact, we've received very few demand letters alleging a constructive dismissal during this time. But some of the factors that I think have mitigated that risk are, how has that change affected everyone? So if it is a change that applies across the board, so all those individuals who have these in and out contracts are being impacted in the same way, I think it's an easier pill to swallow for the employees. Has there been clear communication with these employees regarding the reason for the change and why it is that we think it's better for them, or provides a more safe work environment, or allows us to manage the COVID circumstances in the workplace? I think also helps. setting a limit on the effective length of the change. And then most importantly, I think being flexible to address employee concerns. So if there are issues with respect to childcare or daycare that allow for either a 4-week or maybe even a 6-week in and out to manage those issues, I think go a long way in terms of ensuring that the employee is comfortable with this change for this period of time. And then I would be remiss in reminding employers that in a unionized work environment, you need the union consent. I will say in my experience during this period since March, that this is where having a good relationship with your union partners has really gone a long way.
Nancy, I was going to follow up on that last one really as an extra question. Just, it might be unfair of me to ask, but through this unique time, this miserable year that we're going through, what is your sense? Are indeed employers, employees, unionized, non-unionized? Is there? Have you sensed any better relations? Have you sensed any view that people are trying to work this stuff together collaboratively, or has the needle changed at all in that?
So our experience has been limited to those employers who are operating essential businesses who are unionized. And I would say that to date, I've seen a great relationship with the union and the employer partnering to ensure that the business maintains its viability, and more importantly, that employees are working in a safe work environment. So I have actually not seen any real issues. There is one grievance that I think is coming across in all environments, which is avoiding or restricting an employee who has a family member who works in a long-term care facility or a grocery store, so a high-risk environment, limiting that employee from coming into the workplace. And I hear from my colleagues in the labor field that we're all receiving the same grievances. So that seems to be really the only issue where there has been some disconnect. But on the whole, again, I would say it's been pretty harmonious.
That's comforting to know. Thank you. Before we wrap it up, any closing last thoughts for you, Nancy?
Well, thanks very much for allowing me the opportunity today. I really appreciate it. I must say I'm pretty impressed by how quickly our clients have pivoted to address these questions and to deal with these concerns as they arise. Information is coming pretty quickly. Just think of what we've learned about COVID since March and how employers have had to address that as they've gone along. We have been working as a group and as a firm to provide lots of resources and information. So if you're not already logged in or receiving our blog, it's a great resource to be able to get some of this information and some of these policies that we've talked about. And of course, we're always here to help. Great.
Nancy, thank you for your time today. I really enjoyed and what you had to say. And as always, when we talk about these things, I take something away from it as well. So thank you again.
Thanks, Jay.